Hey crew, just a quick update tonight. This is really just comical at this point, so I'm giving it the respect it deserves and turning it into a comic. We've watched painfully while Team Alex attempted to use machinery in court. We've watched mockingly as they've misfiled documents, doxed their own witnesses, turned in their homework to the court, only to have it handed back with the do it again the right way and refile. And now here we are again, watching with secondhand embarrassment as they make fools of themselves to the South Carolina Supreme Court. Joe McCulloch, desperate to be involved in the Alex Murdaugh case in any way he can for reasons that none of us can understand, filed a petition with the South Carolina Supreme Court, as we talked about before. What was it for? It was another attempt to get the files about egg jurors released from the jury unsealed. Now, the court unsealed them to her and her attorney, but they're not allowed to make them public, and they really want to make them public for some reason, which I'm sure has a lot to do with Joe's good friend Dick. Dick really needs a win with this egg juror to try to get his appeal accomplished. Now, they're trying so hard to make this juror happen. It's really making me wonder if she was some kind of plant all along. It's kind of like the days when old Buster would let his young son pick the names of jurors literally out of a hat. Yes, they really did that. But so far, nothing they've done has worked. When they used her backup, Juror Z, I think people who were once on the side of, hey, this really happened, saw Juror Z in action. Even they were embarrassed. Even they gave up believing in this. So now what can they do? They keep telling the public, oh, they're trying to hide something. They're hiding these files. Could they have misfiled this on purpose just to keep perpetuating that little mystery in people's minds, making them wonder if there really is something awful in those files? I don't know, because what just went down is just outrageous for attorneys who've been attorneys for a combined over a century to have done this big mistake. And I've asked this question before, but I'll ask it again. Why? Why do they want this done? It's not like they can stick her back in the jury room and redo the deliberations and come out with the hung jury. Also, as I've said before, she ran her mouth. It's a fact. Nothing can change that. She broke her oath. She had to be removed. There are witnesses outside of the court, nothing to do with Becky, nothing to do with anyone in that courthouse, that signed affidavits and gave recorded statements saying that she broke her oath. This is the epitome of a dead horse. There was no other remedy other than removing her from the jury, and nothing can change that. 2 courts have already refused to release these files, and so we get this petition that Joe filed with the Supreme Court, and today came their reply, and wow, is it funny. It's so unbelievable that it really does make me wonder, did they do this on purpose? Because they know there's nothing in those files, but if they keep saying this and keep yelling about it, they can make people still believe that something unsavory happened behind the scenes. Because I just can't believe that this was an honest mistake, filing it this way. Let's have a look. So what am I talking about? We learned that they filed this appeal without following the appropriate steps to file an appeal, something that an attorney who's been an attorney for a year should know. We're talking combined over 100 years, these guys. You don't just sit down and write a Dear Supreme Court letter. You have to follow certain appropriate steps. These guys know that. In Alex's appeal, those steps were all there. So how did this happen? But the first thing they've missed is something called a designation of matter. This was filed in Alex's appeal. What is it? It's information that needs to be provided to the court about the actual matter that's being appealed. It can be things like the court transcript, other court materials, something that the court can refer to in order to make an informed decision about the appeal. You can't just come with a petition and say, hey, this court said no, and I don't like that answer. Can you change it, Supreme Court? The document continues. Even funnier, they say much less a record on appeal. So what's a record on appeal? This is a collection of the documents and information that's used by an appellate court to review a trial court's decision. But that last part is the most important, a trial court's decision. You have to have that. That's the basis of your appeal. But Joe just filed this petition by itself, nothing else. They go on, indeed, appellant has only this week filed his initial brief and designation. As such, there was no record before this court to unseal. They have nothing to go on here. Because there was no other reason for Ms. Crosby to intervene in this appeal, we denied her motion on the ground that it was premature. There is still no record on appeal in this matter, but it appears the removal of Ms. Crosby will not be an issue on appeal for which the transcript of the hearing resulting in her removal will be necessary. And then it's even funnier. Further, by order dated November 2nd, 2023, the Circuit Court granted Ms. Crosby's motion to unseal the record of her disqualification hearing, subject to the condition that neither Ms. Crosby's counsel nor Ms. Crosby shall further publish or disseminate the materials. If Ms. Crosby disagreed with the conditions placed on her by the Circuit Court, she should have appealed that ruling. However, no appeal was taken. We therefore cannot rule or comment upon the merits of the trial court's order sealing this record. They didn't follow the steps. And one last embarrassment, on July 12, 2024, Ms. Crosby moved the Circuit Court to unseal the records for all public purposes. This motion has not been decided by the Circuit Court, and we covered this earlier. In the state's reply to this request, this was mentioned. It has not been decided yet. They conclude, because there is no record before us to unseal, and the Circuit Court has not ruled on Ms. Crosby's latest request to unseal the record, we adhere to our decision denying Ms. Crosby's motion as premature and deny her petition for rehearing. And then we have the signatures of the South Carolina Supreme Court justices. At this point, it's just such an embarrassment to everyone involved. I never in my life have heard of a removed juror going on to make this much trouble well over a year and a half after a trial is over. And you know, the more I see certain people willing to do so much to help Alex and his co-conspirators, knowing that it's largely being done without pay, and that it's not doing their reputations any favors, even for example costing Dick his place in the Senate, the more suspicious I become, wondering what information Alex might have on these guys, because it's clearly not to their benefit to do this, and it's career suicide, and yet they're falling over themselves to do it. I'm just at this point not able to make sense of this, but let's sit tight for now and wait and see how they mess up again next time. I'm sure it won't be long. Till then, this is Cassidy O'Connell saying stay well and stay tuned.